that. Thank you for inviting me here to the Nyaya Forum. I thank Vasudha for agreeing to respond. And I look forward to hearing comments. And so Mustafa for agreeing to respond. Thank you. So I'll be talking about this book. This book which got released approximately 3 months back. This is a book about PIL. Now PIL is of course very familiar to all law students. In fact, and non-law students. In fact, I begin with this book with a discussion from a film. Actually, this is a quote from a film called Sahib Didi or Gangster Returns. In this film, there's a character who's like a politician's wife, who's made to be a politician, and she's kind of politically clueless. And the film, to show how basically she's completely ignorant, she doesn't know anything about Indian politics, shows her asking at one point, PIL kya hota hai? What is PIL? If she doesn't know what PIL is, she doesn't know anything about Indian politics. So that is the situation we are in right now. That has become such a omnipresent part of our, of our political culture, legal culture for sure, that has become a symbol of that. In fact, there's a scholar called Nick Robinson who a few years back published an article talking about how the Indian Supreme Court gets much more coverage in the media than even the Prime Minister or the Lok Sabha at the time did. I mean, this might have been true to 2014, maybe not, that's not true anymore, but certainly at that point it was valid. Now, I know all of you are familiar with what PIL is, but to begin with, I just wanted to underline the fact that while our idea of PIL stems from this question of dilution of local standard, this is how we common sensically understand PIL, and that's how, at some level, that's how it began. We have come a long way since then. It's not just about the initiation of the procedure of a case, but the course of this proceeding as well as the outcome of that proceeding at this point. Meaning that the beginning, middle and the end of a case called, which is called PIL is different at some level from a regular case. This is a point I want to underline, and of course it's a writ petition that is specific to appellate courts, as you're familiar. But the broad point I want to make to start with is the informality that marks not just the beginning of a case, but the proceedings of the case as well as the outcome. Now, I want to briefly talk about how I started doing this work. I actually studied law in Bangalore in the late 90s, and at the time, in the National Law School University, and at the time, the idea of PIL was basically, as a kind of mechanism for the greatness of Indian judiciary. That is the one, along with the basic structure doctrine, that was the biggest, kind of achievement of the judiciary. People considered it. That story started changing in the late 90s. Specifically, the Narmada Bachao Andolan case perhaps is the kind of a tipping point where the views on a lot of the earlier constituency of PIL started changing about the judgment that came in 2000. I actually was interning as a law student with Prashant Bhushan in 1999 when the 4-year stay on the construction of the Sardar Sarovar Dam was first lifted in February 1999. And culminated, of course, in the judgment in October 2000. And from then, there's been a kind of a critique from kind of the left-liberal constituency about the PIL has become anti-poor, that it's increasingly, while it was progressive to begin with PIL, it has become become regressive. And there's been a critique on the grounds of separation of powers as well. Now, what I try to do in this, book, and what I try to do today is to depart from this point of view, to the extent that I believe the problem with PIL did not just emerge after 2000 or what Professor Bakshi at one point withily called it the structural adjustment of judicial activism post 91 and especially since 2000. I think the problem with PIL lies right from its origin. And we need to revisit it right from it, that the idea of discontinuity, which has marked the critical discourse in PIL, that it used to be wonderful once upon a time and we had good judges. And with the change in nature, with the changes in political economy since 91 and especially since 2000, that idea of discontinuity I will try to depart from and to make an argument around continuity, that there is a fundamental continuity between the way PIL arose, which I think was a tragedy to begin with, and now of course now it's a farce. and a dangerous one. But that journey, I mean, there's a broad continuity that I will try to trace through this presentation today. Now, to tell you the story, I will provide a kind of a revisionist history of PIL. But to begin with, I just want to underline one last thing, kind of a methodological point, that in this book I've tried to move the focus of understanding PIL, move the focus from outcomes to processes. You know, much of the critique has been that it's become anti-poor in the sense that the cases result in harming the interests of the marginalized, which is, I do not argue with that. I think that's almost a truism at this point. But the focus, I believe, because it's a revolution in procedure, I believe the politics of PIL should not just be looked in terms of its outcomes, in terms of the parties involved, as well as, you know, the idea that the legal is not political, the political lies outside the law is something I want to depart from. If I want to look at the politics of PIL per se, so that's what I'll try to do. Now, so I begin this story with a kind of a revisionist account of the history of PIL. Now, there's been for a long time kind of axiomatic understanding of the history of PIL. You know, the role that the court played during the emergency, it needed to undo it, undo that, you know, exercise it's the history of that performance during the emergency, and for that it needed to go through PIL. But so what I will try to show is that this kind of understanding actually begs the question. Sure, there needed to be a response to the emergency, and it's the court's ignominious role during it, but it didn't have to take the form of PIL. The fact that it did is a historical conjuncture that we have to understand. So that's what I will try to do here. There's a famous quote by L.K. Advani in 1977, just after the emergency was lifted, about the role of the Indian media during the emergency. That the media had been asked to bend by the then executive in the emergency, but it didn't have to crawl. Arguably, the performance of the judiciary during the emergency was no different from the Indian media. In fact, interestingly, the well-known senior advocate Vasudha Nagarajan has argued precisely that in today's Indian Express in a fascinating op-ed which I urge you to read. Now, the kind of common agreement now, it's almost universally shared view that the lowest point in the Indian post-independence judicial history is the case of A.M. Jabalpur versus Shivkant Shukla. This case called the habeas corpus case, which all law students are familiar with. Now, I just want to revise this history. A short kind of idea of what the court was trying to undo supposedly through PIL, and the journey that it did not take is, I think, as interesting as the journey it took post-emergency. So, the Maintenance of Incident Security Act, legislation passed after the 71 war, or during the 71 war, which was amended in 1975 after the emergency came into force, made much more repressive and draconian. This was, under this law, tens of thousands of people were imprisoned, many political prisoners. This was challenged. The detention under this punitive detention law, under NISA, was challenged in many high courts. Many high courts actually came to the rescue of the detainees. Although the argument was that under the emergency, Article 21 and 22 had been suspended. So the right of habeas corpus was supposedly also suspended. That was the point that was that was to be argued. And this came up before the Supreme Court. I'm sure you're all familiar with it. I just want to briefly talk about this. The Supreme Court, of course, by a 4-1 majority, upheld the constitutionality of NISA, as well as says that detention could not be challenged at all if 21 was suspended, and no habeas corpus would survive, no right of habeas corpus would survive the suspension of 21 and 22. This was given a majority which included Justice Ray, Justice Beg, who later became Chief Justice, then Justice Bhagwati, Justice Chandrachud. And the last two names are important because they are in some ways the progenitors of PIL, as you will see. And then there's a famous minority by Justice Khanna. Now, Justice Beg, in fact, in this majority judgment, went on to defend the emergency, although it was not something he was asked to do, really. And even when in this famous statement that the care that the state is taking of the detainees in prison is almost maternal. This is probably the single most embarrassing line the Supreme Court of India has ever uttered. So this was supposed to be the lowest point. Actually, there's another case, Bhuwania, later, which is also quite interesting. Just before the lifting of the emergency, this case called Bhuwania was in the Union of India, where not the detention itself, but the conditions of detention were challenged. The pitiable, miserable conditions that the prisoners were kept in. This itself could not, according to Justice Begin in the Bhuwania case, they said even that could not be done. So what we see here is the court's complete imprimatur, kind of support for this kind of clamp down on civil liberties that we see. Now, after 77, when emergency was lifted, many of the judges who give the majority opinion in these cases were attacked. The argument is that, in fact, it was said that they should be removed from the office, including the 3 judges who were still, who were on the bench at the time, Justice Begin and Justice Bhagwati and Justice Chandrachud. And the argument is that we arose because of that. But the interesting thing is that what did the court do after this? Not just with regard to its role in on civil liberty. You see, after 77, when emergency was lifted, NISA got repealed. Interestingly, COVID was another detention law continued. That's an interesting question that we can talk about later. But in 1980, when Mrs. Gandhi came back to power, she immediately introduced another similar statute called National Security Act, statute very similar to NISA, but not as draconian, of course. So this was immediately challenged. In the case of A.K. Roy versus the Union of India, in 1981 the judgment came. And you can see that this is a kind of a neat opportunity for the court to kind of undo the legacy of NISA. There's kind of a clarity of continuity between NISA and NSA, same political actor, and the same court being asked to precisely do the opposite of what it did in the 18 Jabalpur case. But the court did no such thing. The court, of course, unanimously upheld the constitutionality of NSA. In fact, since then, as you're all familiar, there's been a kind of a series of draconian statutes, most famous being TADA, but many others like ASPA, MCOC, Maharashtra Control of Organized Crime Act, POTA, now UAPA. So what we see from this period is that this alphabet soup of laws, of all repressive statutes, have been consistently and almost always unanimously, with 1 or 2 exceptions, upheld by the Supreme Court. So the court has actually never really undone the legacy of NISA in terms of its opinion on civil liberties, actually. Right down to, I would say, Section 377 IPC of 2013 judgment of the Supreme Court. I would say there's a kind of a broad continuity between ADM Jabalpur and the NAS Foundation case, and of course NPMHR and Qatar Singh and all the other such cases. So what I'm trying to say is that the question of civil liberties has never been, since 75, been of much importance to the court. The court has never really, what we have to remember is that the principal breakdown of the court's, the principal failure of the court during the emergency was on its protection of civil liberties. And this is precisely what it has not undone. What it instead did was take a different path, which is that of PIL. And that's the interesting question. So far, I've talked about why the existing understanding is inadequate about the rise of PIL. And now what I talk about why the response had to be in the form of PIL. The response to the crisis of the 70s. This is the crisis symbolized, of course, by the emergency. So, just to tell you what the court was doing at this point, in 1979, Professor Vinder Bakshi gave this lecture. I think it was called MC Mahajan Lectures, which eventually got published as the Indian Supreme Court in Politics, one of his greatest books, where he first time used this word judicial populism, which is by now many of us use it. He pointed out one specific thing to give you a sense of what is going on. That between 1977 and 1979, the Indian Supreme Court used the expression "the people" in its judgments more often in those 2 years than it did in the 27 years between 1950 and 1977. So there's something with change in judicial discourse, in judicial rhetoric about, and its reasoning itself. And that he calls the rise of populism. Now, of course, for him it was not per se a problem, and that's where we disagree perhaps. But there's a clarity of its move. Now, why did it have to do so? To this, of course, we have to go to a longer history of the Indian Constitution itself. The fact that, as Professor Bhuwania called it, it's a transformative constitution, symbolized by the relative principles of state policy. It's a constitution which provides for certain futures which the state is to aspire to. As Uday Singh Mehta has argued in a very interesting article in Constitutionalism, that it's different, let's say, from the American or most other constitutions, because it doesn't just provide for governance structures and rights. It actually provides for certain futures that the state is to aspire to. But at the same time, it clearly says that it is non-justiciable. That is, it's not directly enforceable by a code of law. So while Part 3 and Part 4, the principal departures that the Constitution made from the prior constitutional structure, what emerged clearly was that, well, Part 3 was, by the Constitution under Article 13, was given the elevated status. It was given a status which was not given to Part 4. But soon after the Constitution came into force, this conflict between these two parts of the Constitution led to the emergence of kind of constitutional battles, culminating in the 70s, as we'll see. Now, you're familiar with this history as law students, I'm sure, but I just want to talk about two particular articles which were used by the legislature to address this challenge. One is Article 31B, introduced by the first amendment itself, through which the 9th schedule was inserted in the Constitution, which was basically a list of laws which would be immune to judicial review for fundamental rights. I don't want to bore you with the history that you all know, but I know this famous quote by Justice Rajendra Garg in the 60s about this strange provision of 31B, where he says that the Supreme Court is unique in the sense of needing protection against itself. So 31B was one response, but in my mind, an even more dangerous in the long term, even more kind of a provision which I believe leads to the kind of half-life of the Constitution being introduced for the first time, is Article 31C, that was introduced in 1971. Now, why did this article come into being, 31C? It is a direct result of the Golagnath judgment, the 11-judge decision, which for the first time said the fundamental rights are unamendable, because, as in Siddhartha's words, the elevated status that the Constitution gives fundamental rights cannot make it the plaything of a special and transient majority. That it cannot just be amended, and it has been amended many times already on the ground 31, of course, on the right to property. Now, this led to a ferocious political challenge posed by Mrs. Gandhi as a result of this decision, because this was seen as a direct attack on the courts, a direct attack on the executive legislature's powers to bring about the social revolution, symbolize the land reforms in particular. Mrs. Gandhi, we forget that one of the principal promises of her famous Garidi Hatao election victory was a kind of attack on the judiciary and its kind of elitist pro-landlord role, which she was going to tame. And the most well-known phrase that came from this political challenge was this term, committed judiciary, coined by her law minister Mohan Kumar Mangal, which was accompanied with another term called committed bureaucracy. Now, so this was the language of the time, and the 42nd Amendment which was the emergency amendment, which made 31C even more important. Let's remember what 31C is. 31C introduced in 71 was basically the provision which said that any law which tries to implement Article 39 B and C of the Constitution will be immune to judicial review on the ground of violating fundamental rights, that is 14, 19 and 31. And this was taken further by the 42nd Amendment, where it said that any law which tries to implement any directive principles would be immune to judicial challenge for the grounds of violating 14th and 1931. So you can imagine any law which tries to ban cow slaughter or introduce uniform civil code or impose prohibition, all aims of the state and directive principles would be immune to challenge and violating right to equality, freedom of property under this. This is of course struck down under Nirma Mills. But I remember what the aim of 42nd Amendment was. The 42nd Amendment is the most thoroughgoing change introduced in Indian history to the Constitution. The aim of the 42nd Amendment, ostensible aim, declared in the statements of purposes and reasons, was to give directive principles higher status over fundamental rights. Right. So that was the kind of project. We forget that the committed judiciary was meant to was supposed to mean commitment to directive principles. So you see the entire ground of this battle is kind of what Granville Austin called the Great Constitutional War between 67 and 73 was laid, but the ground was directive principles. That what we see basically, what I try to argue is that the Supreme Court had to respond and out-radicalize the political masters. But the ground for this battle has already been laid down in the apotheosis of directive principles. Professor Bakshi has argued as early as the early 80s that in these constitutional conflicts, especially Vasudha Nagarajan, of course, being the greatest of them all, both sides, the majority and the minority, start using language which could be considered populist, meaning that both sides are trying to say that the task of dealing with the social revolution is not just of the political of the executive and the legislature, but also of the judiciary. So at some level, the grounds are already laid in those terms. You see that, and this is taken further in this post-77 period. So what I try to say is that the Supreme Court, in search of its new legitimacy, had to respond by mimicking Mrs. Gandhi's populism. So that the ground of this battle basically had already been laid. What I'm trying to show is why the response had to be in the form of PIL. It could not be in the form of civil liberties precisely. The battle henceforth was between the competing populists of the court and the political class, and the court actually, I argue, had become a committed judiciary, but with a very crucial difference, that it declared itself the vanguard of the social revolution. So we see then the emergence of the populist code. This is the why of how, the why of the emergence of the populist code. Now I'll talk about the how of this process. The how, of course, Professor Bakshi, like I said, already talks about the use of the people. There's a very interesting case in 1979, State of Rajasthan, District of India, where basically after 77. Janata government wanted to dismiss all Congress-led state legislature under Article 356, just like Mrs. Gandhi used to do and she did after. And this was challenged by State of Rajasthan. This is actually an advisory opinion, which came before the Supreme Court. Justice Bhagwati gave the majority verdict again, and his reasoning is interesting. He actually said that this can be done, use of 356 to dismiss an opposition government in the state. Because there's a wall of estrangement that has emerged between the government and the people post 77. So he was able to decide what the people think based on the electoral result. You see, there's interpretation of the people and their views based on something. But so what we see, there's still a mediation of the election which decides what the people think. But the court has started speaking in the name of the people. And the most programmatic pronouncement, of course, of what PIL was done in the judge's transfer case, the SP Gupta was which we are all familiar with. But I want to talk about one case which is prior to this. Supposedly the first PIL, which was Sinara Khatun, which is not really a PIL at all, but it is now considered the first PIL. This is a case this is actually filed as a habeas corpus, interestingly, by this lawyer called Kapila Hindurani in Delhi. This was a case which came from the reportage of the National Police Commission, the NPC which had been appointed by the Janata regime after 77, which found in its many inquiries that in Bihar the prisoners, the under-trial prisoners were spending more time in jail than they were punishable for, under the laws they were charged with. She filed an habeas corpus, Kapila Hingorani, saying the detention would be illegal in that case. But the interesting thing is, there was a habeas corpus, you see. The habeas corpus is a very interesting kind of legal proceeding, because it's precisely the kind of proceeding where the victim cannot go to court by definition. So somebody else has to go on her or his behalf. And that is what was extrapolated into PIL and the dilution of locus standi. So what we have to remember though, that in the judge's transfer case, there were two kinds of dilution of locus standi that was anticipated. One was called representative standing, the other was called citizen standing. One was when one would be a situation when victim would be there, but at the same time it would be like a class action suit without the class member being the petitioner, in the sense that there would be some relation to the victim that the petitioner would try to bring to the court. On the other hand, it's citizen standing, where anybody who's as a citizen of India files a case without having any relation with any specific victim at all, bringing any issue to court. But these two kinds of diverging ways of thinking about dilution of locus standi became collapsed into something called PI. I mean, this interesting difference between representative standing, which could take the form of also associated standing. The many cases that have emerged, and we can talk about it, like Safai Karmachari Andolan, etc., which were in some ways a different direction from citizen standing, which is where the petitioner brings nothing new to the court, who are their own individual understanding, became collapsed, and there's a big price to pay for that. So another thing I want to underline here, which we forgotten since, is that this rise of PI was accompanied by another very interesting and enduring kind of critique of the Indian judiciary that Mrs. Gandhi actually had initiated in the early 70s, was to criticize Indian court for being Anglo-Saxon in origin, being colonial in origin, being distant from the needs of the Indian people, and therefore the need to indigenize it, the need to decolonize the Indian judiciary. Now this is of course true, that the Indian judiciary is what it is in terms of its history. We all know how it was introduced. But the point of attack, instead of taking the form of legal aid, which was what it is professed to be, meaning that the idea of legal aid, of course, as you all know, is to provide the indigent and the poor with legal services on behalf of the state or lawyers free of cost or at nominal cost. And this was the language of dealing with this crisis, according to Mrs. Gandhi, the crisis of the judiciary. Various kinds of attempts are made, and in fact, in the 42nd Amendment, one of the amendments was to introduce legal aid as a directive principle under 39A. But interestingly, the response that this challenge to the pathologies of the Indian legal system took was not through legal aid, but to change the very form of the legal adjudicating structure at various levels. And because this was accompanied between 73 and 77 by a series of attempts led by, in particular, Justice Bhagwati and Justice Nyaya, two judges who Professor Bakshi at one time called them susceptible to being called legitimators of the emergency regime because of the role they played in this period. So what happened was, really, instead of providing access to the poor, to the judiciary through the expansion of legal aid, did not really happen. Instead, the structure of the code itself was changed at various levels. Tribunalization was introduced in a big way for the first time in the Constitution. In the 42nd Amendment again. 42nd Amendment is a recurring theme in this history, and it's really fascinating to. I don't think we've understood the impact of the 42nd Amendment and the enduring ways in which it has struck roots in our way of constitutional thinking, and it's something to revisit that I would like to do myself, but I believe many of us should do. So tribunalization at the intermediate level, lok adalats at the lowest level, and PI at the highest level. So this is the phenomenon of called the phenomenon of debased informalism as it got introduced in the 70s and kind of stayed since then. This is of course now taken the form of ADR. It's interesting because mine was probably the first batch in National Law School where ADR has been a compulsory course. And it's interesting how recent vintage it is. Now ADR has become a kind of a shiny symbol of the hope for change in the judiciary. But it's interesting how ADR kind of overlays this critique, this idea of indigeneity, but then somehow it's more suited to Indian conditions, as well as this shiny, American exemplar. You see, it has this global as well as local attributes, which makes it so attractive as this way of solving the crisis, right? So it's fascinating that, and it's really taken roots, obviously, in the last 20 years since I went to law school. So when it started with dilution of local standard, the processes of dilution of basic procedure in terms of writ proceedings and VIL cases is then went much further. So one of the things that happened in the mid-80s was the standard of evidence in VIL cases changing. This was done perhaps most enduringly in the Bhuwania case. This is a case we've studied as one of the great PILs of that period. There are many reasons why there are reasons to rethink the greatness of this PIL, but I'll concentrate on the procedural point alone. Now, in this case, Bhuwania, an organization working with bonded labor, alleged that in Hyderabad, area in Delhi, there were mines in which bonded labor was being used. This was denied by the Haryana government, as it usually does. To deal with this kind of this impasse, the court appointed what is called a socio-legal commission, which was sent to collect evidence on this issue. The socio-legal commission did conclude that, of course, there was bonded labor going on. Haryana government again denied that any such thing happened. But the Haryana government demanded the right to cross-examine the commissioners who had been appointed. But Justice Bhagwati refused, saying that this would be too technical an interpretation in a PIL case. PIL is after all an informal proceeding, and we cannot be. This is not an adversarial proceeding, as he would like to say in PIL case. So because of that, he said that the evidence related to the commission must be final and it cannot be challenged by the other side. Now, this I can understand. I mean, people like us would probably have sympathy with the view that he proposed in this, because obviously bonded labor is such a heinous kind of crime. But the kind of there's this adage you might have studied in legal methods which says hard cases make bad law. This is a classic instance of that, because attempt to do justice to these individuals. What the court did was that it changed the very standard of evidence that could be used in PIL cases, which will lead to devastating consequences, as you will see. Another case where the kind of procedural change was taken further was the Sheila Base case. This is a case where a journalist from Mumbai wanted to she had filed a PIL against the condition of children's homes, which were under Juvenile Justice Act, which were in a terrible condition. And this was heard by the court for a while, but she was not happy with the way the case was going. She was disgusted with the proceedings, frankly. She wanted to withdraw the PIL. This was before Justice Venkat, and he refused to allow her to withdraw the PIL. He said that this would be kind of a walkout of the court, and a PIL not owned by the petitioner, but it's basically PIL is the role of petitioner and PIL going to the court at the time was very minimal. Just analogous to what we study in criminal law, the role of a person who files an FIR. You initiate the proceedings. This is the informant. You bring attention to the police of some crime. But then what the police does with it is its own choice. It's very different from the situation of a complainant in a civil internal procedure. Complainant has to take the case forward herself. So what the Supreme Court did in this case was to reduce the PIL petitioner to basically an informant, and could be removed and the court would continue with the case of appeals. I'll talk about the Gopal case later because of the kind of resonance it has with the rise of PIL and the dilution of procedure. This dilution of the role of petitioner, but the court started with needing a kind of a kind of public-spirited petitioner, as it was called. But we see that by this time, by the early 90s, late 80s, the court no longer needed the crutch of the public-spirited petitioner. The court could directly speak in public interest without even needing a petitioner. And this was taken much further in the 1996 Jayanawala case, the Vinit Narayan versus India. All of you are familiar with it. But continuing mandamus was introduced with Justice Verma. But another very important procedural change that he introduced was he removed the petitioner, appointed an amicus curiae, Mr. Anil Diman, who recently died, and said that any other party who is affected by this case, there were many parties, who should approach the case through the amicus. And this was a practice which became gradually institutionalized by the court. This is now practiced in dozens of PIL cases. And it has had, it has been really, it has singularly changed the very nature of the PIL proceedings. And the most famous of them all, of course, is the forest case, T.L. Godavarman versus State of Tamil Nadu, introduced in '94, pending since then to thousands and thousands of IAs. And you must have studied about this. Arvind Rosenkrantz has written about this case critically, which is fascinating. Basically, forest governance has been taken up, has been basically appropriated by the court since then. But I was talking about one procedure, because my focus is procedure. The case of Niyamgiri Hills, again familiar to you all, the Dongriagon tribal community were to be removed from their from the place they live for the construction of an aluminum plant constructed by, proposed to be constructed by the Vedanta company. Now, in this case, one of the allegations that emerged was that that one of the judges, deciding this issue, this is Kapadia, was a shareholder in a company that called Sterlite, which was basically a sister concern of Vedanta. So there was a kind of allegation of conflict of interest. And in such cases, the norm is that the parties would be adversely affected by the case, let's say, would bring to the attention of the court, and then the judge could decide to recuse himself or herself. But the problem in this case, because of the very nature of PIL at this point, was that all the parties before the court were in favor of the project. So none of them wanted to bring the case to the attention of the court, this allegation of a conflict of interest. So while there are many other aspects to this question of the rights of this community to their land, I just want to bring to your attention the fact that the very procedural change in PIL meant that certain kinds of questions could not be brought to the attention of the court. Because all the parties were on one side, Odisha Mining Corporation, Odisha government, central government, the miners themselves, all of them were in favor of the project. So obviously, this could not be done. So the other kinds of instances that I mentioned in the book, but to kind of bring you the reductio ad absurdum of the most extreme instance, but since then this extreme has been pushed further perhaps, is the networking of rivers case. Now this is a case which started in 1994 when Hindustan Times carried an article called "And Quiet Flows the Meli Yamuna." This court decided to start a PIL based on that, appointed a amicus curiae, Mr. Ranjit Kumar, who is currently Solicitor General, and the court for the last 23 years has been hearing this case, trying to clean the Meli Yamuna. It's now called INRI AFQMY, INRI Quiet Flows the Meli Yamuna. In 2002, in this case, something strange happened. The then President, Dr. APJ Abdul Kalam, gave a speech to the nation on the eve of independence, saying that there's major drought conditions, etc. in some parts of the country, floods in another part of the country, and this situation can be dealt with if interlinking of rivers is done. This appealed to the then amicus, Mr. Ranjit Kumar, who brought it to the attention of the court. The court decided to start another suo motu case, in this suo motu case, which came to be known as INRI networking of rivers. It issued notice to all the parties, in all the states and the Indian government, and asked them for their opinion on this project. Now, as is usually happens, the states did not respond in time. The only state which responded at the time given was the state of Tamil Nadu, which enthusiastically supported this project and still does, as you know. Rajnikant at the time had issued made a statement that he will give 1 crore as seed grant for this project. I don't know if he actually gave, but so that is the kind of popularity it has in Tamil Nadu. The court decided that that because the other states had not responded, they implicitly supported this project, and therefore ordered this project to be initiated at some level. And since then, this was a kind of interim decision. In 2008, Justice Kapadia, in a 3-judge decision, ordered actually have asked for this project to be taken up. Of course, this is the most expensive engineering project in Indian history, even according to the government account, which is more than $100 billion. Of course, the human costs are much higher than could be computed. But I just want to tell you how this kind of case could go in a direction which is difficult to even fathom. Now, to bring you further, to your attention further the kinds of possibilities that PIL can lead to because of these procedural changes. It's this case which we studied as law students as MC Mehta was in Union of India. But MC Mehta has nothing to do with this case for 2 decades now. He's not really been part of this case. So we cannot really rightly call it that he was in Union of India. It's a case which started in 1985 and still pending with the question of pollution caused by stone crushing units in Delhi. At that time, this first cause of action was being adjudicated. Rosencrantz and Diwan, writing the first edition of Environmental Law and Policy in India, talked about the court doing micromanagement through this case. But obviously, this is only the first avatar of this case. We had seen nothing yet. So from this, the cause of action has changed multiple times. It became then about from stone crushing units to pollution in River Yamuna, to encroachers in the rich forest, in which many thousands of encroachers, quote unquote, people living in rich forests were removed. Then it became about mining in Haryana's tourist resorts. This was Surajkot, you might be familiar with. Then mining in Aravali Hills. Then it became about something else which is probably brought it, to the prominence in a big way. This is a case of hazardous and large industries in Delhi. Under the master plan, certain areas were demarcated to be industrial zones where factories were to be set up. But the court decided that that post Bhopal, etc., there are certain industries are too hazardous and they have to be removed from Delhi. This is an area of West Delhi. But in this entire proceeding, the laborers were never heard. The owners were actually happy with the closing of factories because it was no longer profitable to run them as industries, and it was much more profitable as commercial land. Now, at this point, if you go there are basically malls and high-rise residential buildings on that area. So the owners have not really lost out in any way from this. But the laborers, more than 1 lakh of them, they were full-time employees I'm talking about. We're not talking about lakhs who were allied industries who were involved. They basically became jobless overnight. And they were never allowed to be part of the case itself. So this is 96. 2000, the court ordered the closure of all non-conforming industries, meaning all industries which are not located in industrial areas were to be moved. But this affected many more lands. And this, again, the non-conforming industries were not, the people who work in these small factories, basically about 10 to 12 people, were closed down. Many, lakhs became jobless. If you want to read about it, there's a fascinating book of Poverty and Plastic by Kaveri Gill, who's talked about this particular aspect of this case. And for the previous hazardous industries closing, there's actually a very famous report by PUDR, People's Union of Democratic Rights, a report they brought out called The Order That Fell the City. What I try to say is that the city has been felled multiple times by this one case, and most famously, which you might be familiar with, by the last of its many avatars, the Sealing case, which is closing of all commercial establishments in non-commercial areas, which affected many more lakhs and became much more conspicuous. But the interesting thing about this case is that neither can be identified with the petitioner's name or with the cause title, nor can we understand it through the cause of action. Because the cause of action itself has changed so many times. The only thing we can call it is writ petition 4677 of 1985, because it makes no other sense. We cannot really. There's no adequate appellation for a case of this nature. So this is to bring home. Obviously, this case led to many kinds of difficulties, as well as the systematic deindustrialization of the city was achieved. The city as large as Delhi, with lakhs of industrial workers, was achieved through one case. But But what I want to focus on is the procedural aspect. The next kind of focus that I have, actually much of my field work in this for this book was done on this matter of slum demolitions. My PhD is actually in anthropology, and like I was saying, while I had a certain view of PIL, which was post Narmada, the disappointment, etc., I had not really understood the extent to which the code had changed. Because my critique was again ideological of PIL, it was not material. But what I saw in these cases was to bring home to me just how far the code in PIL is from our regular ideas of code procedure. Anything, and I practiced for a year in Delhi, mostly in criminal cases, but also some PIL cases. In fact, what you might notice actually is that my critique of PIL is actually a criminal lawyer's critique as well. As in my kind of shock at this complete adherence to lack of adherence to procedure is perhaps from my training as a criminal lawyer, because for criminal lawyers, procedure is where the rights are. We cannot think of rights without its kind of material location and procedure. Anyhow, now in these cases, what I started seeing, what I'm trying to say is that the kind of an empirical view of law, which thanks to my disciplinary background I was able to do, provides a different view of the court process than just the kind of training we get as law students. Because you see, law students are meant to read judgments, interpretation of statutes, etc. But the way in which the court works and how its everyday reality is something that you see closely when you try to do empirical work. Of course, lawyers and journalists are very well aware of this. But as law students and as legal academics, we miss this perspective. Anyhow, to talk about this kind of bunch of cases, in the first decade of the 21st century, the Supreme Court and the Delhi High Court presided over the most systematic slum demolition campaigns in India's history. This period, 2000 and 2008, saw about 1 million people being evicted through slum demolitions. In this ferocious campaign carried through PIL. This campaign can be analogized to the only other such instance, which is during the emergency when Delhi saw about 400,000 people being evicted. But even that was only less than half the number that were evicted by the PIL-led demolition campaign. I call it PIL as a slum demolition machine. And it is a highly effective slum demolition machine, precisely because of the nature of PIL. You see, much of the critique of these cases have come from a point of view that the court is middle class, has been kind of a middle class bias, it's become anti-poor, etc. But all that is true. What I'm trying to focus on is the fact that while that is probably true about most judiciaries anywhere in the world, that they have middle class biases, they come from a certain elite, they come from a certain class, etc., etc. But only the ancient courts, and now the Pakistan, Bangladesh, Sri Lanka, Nepal courts, who have also adopted this path of PIL, can carry out a campaign like what was done in this period through the mechanism of PIL. PIL has made them all powerful. And one of the principal departures in the form of litigation in these cases is that of geography. Normally, you would think that one party brings issue to court and the other party contests, and it's about a particular subject area. An RWA, let's say, a kind of a resident welfare association brings an issue to court, some illegality, etc., etc., and the court orders its removal in that area. But what happened in this period is that through PIL, the cases would no longer be about one settlement, one area. It would be about the whole of city of Delhi. So there would be one in-read begging case, there would be a case relating to street vendors in Delhi, there would be a case relating to traffic conditions in Delhi, there would be a case relating to road transport in Delhi in general. There would be a case relating to, that's the largest of them all, which is where I did most of my fieldwork, which was the unauthorized construction in Delhi and encroachment on public land. So the cases are no longer about one party versus another party. It's really about it's a kind of a policy issue which affects the whole city, which is taken up by the court. And here I want to talk about the most famous, infamous slum demolition that was carried out by the court in this period. 2004, they demolished this slum cluster called Jamuna Pushta. more than 200,000 people, more than 2 lakh people used to live next to the Yamuna in the area of Pushta. Now, a lot has been written about this case, but what is often forgotten about this case is that this case, where the case which came up, where this issue came up and where it was ordered, had nothing to do with Yamuna. This case actually was brought to the attention of the court through two middle class, associations filing a PIL about removal of slums from that area. But the court, apropos of nothing, decided to make it a case about Yamuna and its pollution, and the pollution would be dealt with by removing people who live next to the Yamuna who cause most of the pollution according to the court, and therefore it ordered an appointment of a amicus curiae, Mr. Amarjit Singh Chandyok, and ordered for the removal of this basti also. So what we see is that it came up with its own facts, its own allegations. It initiated the case itself. It came up with its own evidence. It came up with its own findings also, ordered its judgment also, and appointed a kind of a implementation mechanism also. So you see, it's a remarkable thing that the court could do in this case, and that's something. With all its biases, that's fine, but the fact that it could go about doing this, you see, situations like this, the existence of slum clusters, etc., of this scale, and the removal of them, it's not easy for a political executive to carry them out. You see, these are politically volatile situations. Closing down factories where lakhs of people work, or removing people from their houses in lakhs, is not something that any political executive in a democratic country can do. But the court can do this. And interestingly, the only other regime which could do this so easily was the emergency period. So there's a kind of a continuity what we could see with the emergency regime and the kind of regime that we are institutionalized. And interestingly, in this unauthorized construction case, which is why I did my work, the court had divided Delhi into 12 municipal zones, appointed 12 commissioners, 12 of its favorite lawyers as commissioners, and asked them to bring to the attention to another mechanism called monitoring committee that the court had set up of any illegalities in their area, and the illegalities could be removed based on their findings. Basically, they had created a kind of mechanism for removing all the illegalities through this through the court commissioners. Now, I interviewed one of the court commissioners in this case, asking them how it can be done, and this seems beyond any understanding of legal procedure that one could have. And what he told me was very interesting. He said, this is exactly like Bandha Mukti Morcha. This is exactly what they did with Justice Bhavati did with Bandha Mukti Morcha. Appointed commissioners found evidence, found illegalities, and remedies were ordered. So, how different is it from that? And as you call it, it was a glorious period of in these cases. Now, to bring home to you how far these cases are from any pre-trial understanding of procedure, I want to bring your attention to this case of 1984 from the Gujarat High Court. This is the standard situation which you are familiar with now, and the middle class, residents go to court saying that people living in the area are defecating in public and causing nuisance, and therefore they have to be removed, etc., etc. Now, the court interestingly rejected this petition. But the reason it gave was not some kind of ideological argument. It was purely procedural 2 points that it made. One was that the remedies sought against people who are not being brought before the court. They are not parties to the proceedings, and as necessary parties in the civil procedure, you cannot order a relief against people who are not parties in the proceeding itself. So therefore, it cannot be done. And the second point it made was that as a writ court, it cannot adjudicate the question of fact. So therefore, it's not competent to issue to give any relief in this case. Now, this kind of arguments were no more made in the kinds of cases that we witnessed in the 21st century.